Homework, the biggest problem with the homework is that some people chose not to read the instructions and didn't do what the homework asked. But apart from that, everybody did, I think, a pretty good job. They didn't have any really incomprehensible papers, and I find it quite fascinating to grade all of the different proposals that people have, and enjoy that quite a bit. It's what I spent last weekend doing, so it's my idea of fun. Today we're going to talk about copyrights. I'm going to start out with the definition of copyrights: a right to exclude others from copying, distributing, making derivative works, or publicly performing an author's works. Works may include literary, dramatic, musical, and artistic works, technical manuals, computer programs, and certain other works, whether published or unpublished. Lots of things get covered by copyrights. Copyrights are really pretty nice because they're very simple and automatically arise. Copyright laws are passed by the Congress under Article 1, Section 8 of the United States Constitution. And that provides that Congress shall have the power to promote the progress of science and the useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So the United States Constitution expressly gives the federal government the power to grant copyrights if they so choose, and to grant patents if they so choose. Interestingly, it does not inherently exclude the states from having that power. And in our early history, the states did grant patents, and up until a few decades ago, the states provided what is referred to as common law copyright. At the current time, the federal law pretty much has preempted the state action in those areas, although scholars sometimes argue that the states still have the power to grant both copyrights and particularly patents, but none of them try. So the federal government pretty much is the sole agent for establishing and enforcing both patents and copyrights. The purpose of copyrights is to prevent substantial copying by others who have not themselves made the required effort to create their own expression of a particular idea. So in copyright, substantial copying is the test. You compare that in trademark law, it's the likelihood of confusion. That is the test. And in patent law, it is the infringement of the patent claim. That is the test. And for validity, it's whether or not the invention would have been obvious to a person of ordinary skill in patent law. Copyrights provide an incentive for authors to publish their works without fear that others will easily profit from the way they have expressed their ideas. Note that the copyright only protects the expression of the ideas. It provides no protection whatsoever on the underlying ideas. Basic copyrights are automatic. Copyrights arise automatically when the author generates his work in a fixed medium, regardless of whether or not he goes through a formal process of registering his claim to a copyright. Registration may be made at any time within the life of the copyright. What did I do there? Let's try again. The law at one point in time said you had to register your claim for your copyright promptly, and there was a court decision that says if you do it within 28 years, that's prompt enough. And so as a practical matter, any time you register is just fine. Neither obtaining a copyright nor registering a claim to a copyright normally requires a lawyer. This is a do-it-yourself thing that you pretty much can do on your own. The term of a copyright, and there are several categories, and this is for copyrights that were created on or after January 1st, 1978, when the latest copyright law that changed the term passed. And that is 70 years from the last surviving author's death. Unless it's made for hire, or if anonymous, it is then 95 years from publication or 120 years from creation, whichever is shorter. So those are the two different terms for copyright. It would be very helpful if you remembered those when the final exam comes along. Come in handy. Unlike patents and trade secrets, no joint owner of a copyright may license a third party without the consent of the other joint owners. And all royalty income that any one copyright owner receives has to be shared equally among the owners of the copyright, absent an agreement to the contrary. So in copyright law, everything is share and share alike. If you license, you have to share with your other owners. With patents and trade secrets, there is no accounting from one owner to another. If you want to license your partial interest in a patent, you can license that and keep all the royalties yourself and not pay anything to the other joint owners. You can do that for patents and you can do that for trade secrets. You cannot do that for copyrights. Of course, if there's an agreement, that trumps all of these default rules. You can have an agreement to do it however you wish. Mere ownership of a book, manuscript, painting, or other copy or phonorecord does not give the possessor of those things the copyright. The law provides that transfer of ownership of any material object that embodies a protective work does not itself convey any rights in the underlying copyright. So just because somebody paints a beautiful picture and gives it to you doesn't mean that you then have the copyright in that picture that you received. That person who painted it still has the rights to that copyright unless they assign that to you in a separate document. You have the right to display that work, and you're not going to be sued for infringement because it was given to you. You have a license under that particular copy, but you don't have the right to make more copies and charge people money to have copies made. Now there's a category of copyrights that are referred to as work for hire, and this is a pretty significant category. A work created by a person belongs to that person unless it was within the scope of the person's employment or subject to a contrary agreement which has the phrase work for hire clearly stated within it. Those are the two ways that you typically have works for hire. There are some additional ways that are listed here for a work being a work for hire. But typically it's because you're employed or because you have an agreement that expressly says it's a work for hire. Now, in addition to the copyright laws, protection against copying, there are also laws that relate to rights of attribution and integrity. These are not, strictly speaking, copyright rights. These are independent areas of law. For certain works of visual arts, there are additional rights that the work be properly attributed to the author and not to another. This is true whether or not there's a copyright in the underlying work or not. If somebody else makes the work, dedicates it to the public, and there's no copyright that remains or the copyright's expired, there's still a duty that you properly attribute the work to the author for certain categories of visual arts. And except for works for hire in commercial media, such as movies and magazines, that the works not be intentionally distorted, mutilated, or otherwise prejudicially modified, and that if the work is of recognized stature, that it not be destroyed. That's a really interesting legal construct, and that basically says that if you have a building and you invite some artist to paint a mural on the side of your building, and that work is of recognized stature, you're no longer entitled to tear your building down or put siding over that. You're obligated to maintain that in an undestroyed condition. That's a subtlety that sometimes catches people by surprise.
You said if it's only for work for hire, then?
If it's a work for hire and you hired the person to do it, and normally if you're hiring somebody to paint a mural on the wall, you'll have some written contract that extinguishes this right. But if not, if you haven't extinguished this right, then you can't tear down that building or paint that wall. The registration procedure, if you choose, you can go through a registration process to register your claim to the copyright with the Copyright Office. And it's a $35 fee if you do it electronically, and you have to deposit a copy of your work. The forms and instructions are online, and they're pretty much self-explanatory. For computer programs, you don't deposit necessarily an entire copy. You're supposed to disclose the first 25 and the last 25 pages of the source code of the program if it's printed out, unless they contain trade secrets, in which case there are all kinds of alternatives. The Copyright Office has a circular, is what they refer to it, as a little how-to procedure that you can follow if you have a computer program, so that you know that you don't have to disclose the whole computer program. You don't have to enable somebody else to just copy your source code. You can just give it snippets of the source code, keep the really secret stuff secret, and nonetheless get a registration of your copyright on your computer program. Now, there are significant advantages to going through the registration process. First, it establishes a public record of your claim to the copyright. And for works of United States origin, registration is required to pursue an infringement suit in court. If made before or within 5 years of publication, registration will establish prima facie evidence in court of the validity of the copyright and of the facts stated in the certificate. So if you don't wait this 28 years and you reasonably promptly make your claim for the copyright through this process, if you do it within 5 years of publication, it makes it a little easier in court. Whatever you say in your copyright certificate is going to be presumed true, although if shown to be false, they can undo that, but at least it makes it easier in court to prove those facts. Most significantly, if registration is made within 3 months after publication of the work or prior to an infringement of the work, statutory damages and attorney fees will be available to the copyright owner in court actions. And that's very significant because attorney fees can be significant, and statutory damages, as we will see, can also be very significant. So if you do register your claim to your copyright within 3 months after publication or prior to the time an infringer infringes, then your remedies are much better. If you don't timely register and somebody infringes before you've registered, then you can only get the award of actual damages and profits that you might be able to prove. And that's oftentimes harder than proving statutory damages, and you don't get your attorney fees if you don't promptly register. Another advantage of registration is that the copyright owner can ask the Customs Service for protection against importation of infringing copies. There are some things that are not protected by copyright, and by way of completeness, we'll mention those. Things that have not been fixed in a tangible form of expression, One example is choreographic works that have not been notated or recorded, or improvisational speeches or performances that have not been written or recorded. Those are not protected by copyright. Titles, names, short phrases, slogans, familiar symbols or designs, mere variations of typographical ornamentation, lettering or coloring, mere listings of ingredients or contents are not protected by copyright. And fundamentally, copyright cannot protect ideas, methods, systems, processes. The underlying essence of what it is you're conveying by the copyright is not protectable by the copyright. Only that particular expression that you're using to convey that information is protectable. Somebody else wants to read it, learn what you've said, and write it in their own words. They have not infringed your copyright. So the ideas are not protected in any way by copyright. Publications of the U.S. government are not protected by copyright. And works consisting entirely of information that is common property and containing no original authorship. For example, standard calendars, height and weight charts, tape measures and rulers, lists or tables taken from public documents or other common sources are not protectable by copyright because there's no inherent expression of an idea that's involved. Another aspect of copyright law that gets a lot of attention is the fair use defense. In theory, you're not supposed to copy anything that's copyrighted. At least you're not supposed to make substantial copying of anything that's copyrighted. You can make very minor copying of small parts of it, but not substantial copying. The fair use of a copyrighted work for purposes such as criticism, comment, news reporting, teaching, including multiple copies for classroom use, scholarship, or research is not an infringement of copyright. So this is a huge loophole that if you fit in it, you don't have to worry about copyright. But you have to fit in it. If you have some commercial motive or focus, then the odds are much less that it would be considered a fair use than if you're doing it for a news or political or critique purpose or for scholarship or research. So the standards of what is copyright infringement varies based upon the use to which you are putting it, and it varies based upon whether you have a profit motive or a not-for-profit motive. The nature of the copyrighted work is one factor that's considered in the fair use defense, and the amount and substantiality of the portion used in relation to the copyrighted work as a whole is considered. The effect of the use upon the potential market for or value of the copyrighted work. And that's an important one. If, in fact, by your copying parts of what it is that is copyrighted, you actually enhance the sales of the original work, then that's more likely to be considered a fair use that you've done. If, in fact, when you copy it, then people no longer buy the original work, then that's less likely a fair use. And so that goes into the equation of balancing the equities to determine what should be a fair use. Now, there's a specific reverse engineering defense in the context of software programs that relates to the copyright laws. Normally, you can't copy computer software that's covered by copyright, but there is an exception that says you can copy to find out how to interface another program with the copyrighted program. You are entitled to copy. You're entitled to analyze the computer program, to reverse compile, to break the encryption code or whatever to let you get in to see exactly how it is that the thing works so that you can write your own program to interface with that, and for that limited purpose only. Now, if the interface specifications are readily available from the owner of the copyright, then you're not supposed to do this sort of thing. But if they refuse to give that to you, then you are entitled to to what would otherwise be a violation of their copyrights in their software in order to access the program to interface your own program with it. Now, a lot of times you see in publications copyright notices for works published before 1978. Generally, all claims to copyright were lost and the work entered the public domain if the work was published without a notice of copyright. A typical example of a notice of a copyright would be copyright 1975 Walt Disney Company, either with the word copyright spelled out or the encircled C. And prior to 1978, if you ever published your work and you didn't put that notice on there, that dedicates the work to the public. And thereafter, there was no ability to claim copyright. That's no longer the rule, but that was the rule before 1978. And so you'll come across things that you know were published before 1978 that don't bear a copyright notice. You know you're free to copy them. Now, if you do put a copyright notice on and the work is infringed and the copy the infringer had access to provided that copyright notice, then it's more difficult for the infringer to claim innocent infringement to try to reduce the amount of actual or statutory damages that are going to be assessed. Now, how do you prove infringement? Infringement is proven by showing two things. First, that the infringer had access to the copyrighted work, and secondly, that the copyrighted work is substantially similar. If you prove those two things, then it's likely that you will be able to prove your case of copyright infringement. Proof is bolstered by the presence of common errors in both works, striking similarities in textual content, and structural similarities in themes and factual details. Both individuals and corporations are liable for copyright infringement. Just as in other areas of intellectual property, each person taking part in an infringement is personally liable regardless of the fact that he is employed by a corporation at the time of his actions. However, normally, unless a person is the main actor in the infringement or the main owner of an involved small corporation, the person is not the target of enforcement actions.
Is that just due to cost?
It's due to cost a little bit, but more due to the equity involved. Sympathy is sometimes generated if you're suing this hapless employee who was involved, but it's really the corporation that has the money that you care about. And why pick on that little guy? It doesn't really help you in front of the jury that's trying to give you damages, that you're hauling this guy into court. They don't like that, even though legally you may be legally entitled to do that. It doesn't set well, and so generally people don't do things that alienate juries. One who contributes to the act of infringement is liable as an infringer, even though he doesn't infringe himself. A manager directing an infringing copy to be made is just as liable as the person making the copy. The owner of a theater who receives revenue based on ticket sales is liable when an infringing play is performed, even though he didn't perform the play or even select the play or may not have even known what play was being performed. But he's getting a cut of the revenue and he's going to be liable for copyright infringement. Officers and stockholders of small corporations who can control and have direct financial interest may be liable for the corporation's infringements, even though they have no personal involvement in the actual infringement. So those are sort of indirect ways that you can have liability for copyright infringement, even though you aren't the person who's directly infringing. Now, this is a big deal here. We're going to start talking about statutory damages. We talked about the fact that you can only get statutory damages if you promptly register your claim to your copyright or you register it prior to the time of infringement. But assuming you do, statutory damages are really quite a powerful tool for the copyright owner and quite a threat for the hapless infringer. For different types of infringing activities, Congress has specified by statute amounts of damages which can be claimed without the need to prove that those were the actual damages. Congress just says, for this, it's going to cost you this much. I don't care what it really damaged anybody about. This is how much you can get for damages. Statutory damages can only be claimed if registration was obtained prior to actual infringement. Now, for statutory damages, as to each infringed work, the court selects from $750 up to $30,000, where the infringer had no reason to believe his actions infringed. So that would really surprise somebody who copies something not appreciating that it's a copyright infringement. He could be liable for $30,000 for having done that, with no damages that are proven, because statutory damages don't require proof of damages. The court just gets to assign those. And it could be up to $150,000 if the infringer really knew that he was violating the copyright, and there was a copyright notice on the work, and he copied it anyway, and he laughed, and he told his friends, I'm not worried about this copyright infringement. Well, statutory damages can be $150,000 in that case, which is quite a bit of money for a college student. Actual damages can always be proven, and generally it's proven by the infringer's gross revenue, less the infringer's proof of deductions, and it's pretty hard sometimes to prove the infringer's deductions. So sometimes the actual damages somewhat come close to gross sales. So those can be substantial as well. Plus, if the registration was made before the infringement, there's the claim for attorney fees that can be quite substantial to tack onto this. Additionally, in addition to the money, the attorney fees, and the damages, you can get injunctions against future infringement. You can get impounding or destruction of copies. You can pay the court costs in addition to the attorney fees. You are much more likely to receive an award of attorney fees if you're a copyright plaintiff than in other intellectual property cases. There is also a provision in some cases where you can take the amount of damages that are actual damages and multiply them times 3 and award that. So Congress, in its wisdom, has provided for rather substantial damages claims for copyrights, even though they're a pretty simple right that arise automatically. The damages can be substantial. And we're going to give you an example here. In 2007, the Recording Industry Association of America sued college student Joel Tenenbaum for copyright infringement for downloading 7 songs and file sharing them publicly over the internet. A jury found that Joel willfully infringed and awarded $675,000 in statutory damages. Tenenbaum challenged the constitutionality of the damages award, claiming that the award was so excessive that it violated the Due Process Clause of the Constitution. The judge agreed and reduced the award to $67,500 for those 7 songs, but an appellate court found this reduction unconstitutional, and so it reverted back to the $675,000 judgment against this hapless college student for downloading 7 songs and file sharing them publicly. In another suit by Capitol Records, a court earlier this year ordered a judgment of $222,000 against Jamie Thomas Rassett for non-commercial downloading and distributing 24 copyrighted recordings through a peer-to-peer file sharing network. The court stated that Congress intended the copyright statute to encompass infringers who act without a profit motive and allowed a broad range of damages based on the nature of the violation. Statutory damages are punishment for violating public law, and as such can exceed the actual harm suffered as a result of infringement. So that judgment of $222,000 stuck, and at least for now, that's what Jamie has to deal with. So copyright infringement is pretty significant on occasion.
Just a general question. I mean, what do these people have to do? I mean, they just commit or file for bankruptcy and just.
Well, I would assume if.
Is that all they can do? I guess. Does that cover it?
Well, that would extinguish the $222,000, but it's certainly a hassle to go through for downloading 24 songs and making them available for peer-to-peer. It's quite a consequence to have. I don't know whether he has rich parents and had a trust fund or something else set up that would interfere with his bankruptcy proceeding. I don't know.
I guess the real thing was the problem is that he shared it with others, not that.
Well, if he didn't share them with others, probably nobody would have found out about it, and he wouldn't have been sued. But the moment that you put on a peer-to-peer file sharing network, you're saying, "Hey, I don't really care about the copyright laws."
But how are these people picked out?
It's up to the copyright owner. He can pick whomever he wishes. And they might have written him a letter, and he might have gotten snotty with them and given him a hard time. And they said, "Okay, you're going to give us a hard time? We need to make a test example. You would be a perfect person." If he had gotten a notice from him, and he said, "I'm so sorry. I apologize. I'll never do it again. Here's my whatever," that would certainly have helped. My guess is he probably took a different tack and probably didn't help himself. But I don't know. Maybe he was reasonable and kind, and these people just wanted to have a test case, and set it up, and to have people like me tell other people about it.
What's the law like if this was a peer-to-peer network hosted in another country?
Well, the person in the U.S. that downloaded it, copyright infringed, there's an enforcement issue, and then they might have to go to the other country and deal with them, and through treaties, and you can get international coverage with your copyright through treaties. That's a much more long and involved process. My guess is these people are all U.S. citizens, and that they probably targeted them because they were an easy target, and that they probably would put off the pursuit of the websites that are located outside of the United States. But there are mechanisms that are being developed to better handle the international issue that you raised, and that's a good point. But if you're in the United States and you download them to that Bulgarian website, you are violating the law, and you could be a target. Now, we've talked about civil consequences, a lot of money. You can actually have worse things happen. A person willfully infringing a copyright for purposes of commercial advantage or private financial gain. Now, this is not a non-for-profit thing. This is where you're really trying to make money. By reproducing or distributing copies with a total retail value of more than $1,000, for a first offense can be imprisoned up to a year, or 5 years if the works have a value of more than $2,500. So not only can you have these huge judgments against you on the civil side, you can be put in prison. The copyright law is pretty aggressive. In contrast, the patent laws are not criminal. You can infringe every patent in the world and never run the risk of going to jail or being fined by the government. You can get sued for infringement, and you may have to pay damages, or you may not, or you may prove the patent's invalid, but that's just a civil side issue. With copyrights, the government can actually come after you and put you in jail. And that's a big difference. And really, you shouldn't have to infringe a copyright, because copyrights don't protect any underlying idea that you have to use. Copyrights are just a shortcut because you don't want to express the ideas yourself. You want to use somebody else's effort and not put in your own time. So there's a really good reason for the rationale that make higher penalties for copyright law than there is for patent law, because in patent law, the use of the idea may be essential to serve the public. You never have to infringe a copyright to serve the public. You can always design around a copyright by originating the same kind of thing yourself to achieve the same subject matter yourself. But for patents, it's quite different, and therefore it's not criminal in the United States. There are also criminal consequences for placing a false copyright notice on an article or removing or altering a notice of copyright with fraudulent intent. And for that, you can be fined $2,500. Or when you apply for your copyright registration, you make a false statement, you can have another fine of $2,500. So there are some consequences there. Now, statutes of limitations, I think these are really important to know. For civil copyright matters, it's 3 years. If whatever you did with your file sharing was more than 3 years ago and you haven't been sued yet, you're in the clear. For criminal copyright matters, it's 5 years, so the government might still come after you and put you in jail, but unlikely. There's no civil matter. When you compare that with patent infringement, that's a 6-year statute of limitations. It's much longer and for good reason as well. Foreign coverage. Now, there, just as there are in the trademark arena, we learned about the Madrid Protocol, and in the patent arena, we learned about the Patent Cooperation Treaty. In copyright law, under the Berne Convention and the Universal Copyright Convention, to which almost all countries have agreed, foreign copyright owners are to receive at least as strong copyright protection as the country's own nationals receive. And it's not a difficult thing to later get registration in foreign governments, foreign countries, for copyrights that originated in the United States if you see a need to expand your coverage through registrations outside of the United States. It does not ensure that the protection for the copyright will be for the same term as you get in the United States, and not necessarily the same subject matter is copyrightable in other countries as it is in the United States. These conventions do simplify obtaining international protection. Are there questions? Everybody's going to run home and take down their peer-to-peer file sharing that they have? Okay. I would particularly encourage you to come to our next lecture. It's much more interactive than our other lectures, and it will draw upon everything that we've done up till now, and it's a lot of fun. So, question?
For the final, should we just look over the notes and then with that, what's going to be on it, I guess?
What's going to be on the final? I will tell you what's not going to be on the final exam. What's not going to be on the final exam is how do you draft patent claims. I don't really care. I've already tested that. You've done homework on that. Drafting patent claims is not on the final. Everything else is. So you need to know, for example, how long does a patent last? It's a utility patent. How long does a design patent last? You need to know a little bit from each one of the lectures. It's sort of spread across all of the lectures. It is all drawn from the handouts. There's nothing you have to remember that I've said that isn't in a handout. It's a blend of multiple choice, fill in the blank, essay, all of those mixed together. And generally speaking, there's a wide range of performance on how people do on the finals. And some people think it's really easy to wing it and find out that it's not. And other people study very hard and do very well. And so there's just generally a broad spectrum of grades in the final that really has quite an impact. But it's more like a conventional course than what you've had up till now with the homework. Up till now, it's been more of a creative, intellectual, analytical process. The final is more, what are the rules? tell me about trademarks, tell me about patents, tell me about copyrights, employment. There are 2 essay questions that will mimic what we're going to do next period in our lecture. The one of the essay questions is precisely the same as one of the samples that we'll do next time. So if you remember all of them, you'll at least get one of them right. And the other one is a creative alternative that it won't be exactly like what we do next time, but those are sort of fun. They're just hypothetical fact situations that you have to try to apply what you've learned to those. But we don't really deal with inventions and claiming at all on the final. More just what are the rules of patents, trademarks, copyrights, trade secrets, litigation, trademarks, whatever. There you go. Okay, thanks. We'll see you next